Estate planning and your home, tax and probate pitfalls. Everybody, I'm Christopher Small. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. If you need help with either of those things, please go to cmslawfirm.com. Set up a time to talk with us over the phone for free. Okay, today we're going to talk about estate planning and your home, probate and tax pitfalls. There are sort of two tax pitfalls when it comes to your home, and there are two probate pitfalls when it comes to your home. If you do the wrong thing, you can have unintended consequences. Things cannot work out the way that you want. You can end up paying more money in taxes. You can lose your house. You can do all kinds of crazy things. So let's talk about these just one at a time. Taxes first, because everybody wants to save a little money. So tax pitfall number one, this is also the biggest mistake that I see homeowners make when it comes to trying to deal with estate planning in their home. And that is giving away their house to a child. Most of the time they do this to avoid probate. We're going to talk about another pitfall of doing this. But there's a serious tax consequence to giving your kids your home while you are still alive. When you do this, you are missing out on a huge tax break. It's called a step up in basis. All right. You don't have to Google it because I'm about to teach it to you. The way the step up in basis rule works is when you die, everything that you transfer after death gets a step up in tax basis. What the heck is that? So everything that you purchase, including your home, has a tax basis. It is usually the purchase price of the home when you bought it. So if you bought your home in 1990 for $100,000, your tax basis is $100,000. If you would sell your home while you're still alive, you are going to pay capital gains tax on the growth over $100K. All right. Now, I know there are some exemptions there. You get some room. Don't worry about that. Just generally, the gain over the purchase price, your income tax on when you sell the property. Okay. Capital gains tax is what that's called. The tax basis, what you bought the property for, sets the floor, and everything over that is what you're going to pay tax on. Okay. If you give your house to anybody, including your kids, while you're alive, they are going to receive your house with your tax basis. So if I have a house that I bought for $100K, I give it to my kids, they're going to take it with a tax basis of $100K. What does this mean? When they sell a house in the future, they are also going to pay tax on everything over $100K. Make sense? This is the beauty of doing this the right way. You can eliminate completely all of the tax that you might have on that gain if you transfer the property after you die. Here's how it works. Let's say you bought the property for $100K. Now it's worth $1 million. Okay, so you have $900,000 of appreciation over time. If you wait until you die to give your house to your kids, when they receive your house after death, the tax basis resets from $100K to $1 million. So all of that gain, there is no tax on that gain. So if they get the house after you die and then sell it, they would only pay income tax on the gain over $1 million in our example. Okay. If they sold it soon after you died, they would pay no income tax at all. No capital gains tax. None. Zero. Most people miss out on this opportunity because they think they are doing the right thing by giving their kids their house while they're still alive. Don't do that. Okay. So that is tax pitfall number one. Let's talk about tax pitfall number two. Okay, this relates to Washington state estate taxes. Okay, so Washington state has its own state estate tax. The exemption amount is $2.193 million. So basically $2.2 million. This pitfall, by the way, is only going to apply if your home value is north of $2.2 million. Now, it's not everybody, but in the Seattle area, real estate is expensive. So it's going to be some of you. This can also apply if your overall estate is over 2.2 million and you want to make sure that you keep your house, you're also going to want to pay attention to this. Okay. So if you are over 2.2 million, you're going to start to pay some estate tax when you die. Okay. If you want your house to stay in your family, you need to make sure that there is some liquidity to pay that tax so they don't have to sell the house to pay the tax. Hopefully that makes sense. Let's say you owe $100K in estate taxes, and the only major asset that you have is the house. If that happens, you're going to have to find some way to squeeze $100K out of that house. That usually means selling the house to get the money to pay the tax, right? There is a Reasonably easy, one reasonably easy way to get around this is to get a life insurance policy. Okay. Figure out generally what your tax might be, get a life insurance policy for that amount of money, and then that will be set aside to pay the tax. There's some extra things that you can do to sort of get that life insurance money tax-free, but you should call us, okay? Or set a time to talk with us, cmslawfirm.com, by the way. So if you're not ready for this estate tax bill, you can have to sell your house. Okay, so that's tax pitfall number 2. All right, now let's talk about probate pitfalls when it comes to your home. The first probate pitfall is giving your house, it's the same as the tax pitfall number 1, which is giving your house to your kids before you die. You think to yourself, oh, we're going to avoid probate. I'm going to give my house to the kids. I'm going to live in it, for the rest of my life. And then everything is good. It's great if everything goes according to plan. But what if your kids are sued? Okay. And as part of that judgment, whoever sued them comes and takes the house. It's possible. What if they decide they want to sell the house? They can do that because they're the owners. It's possible. What if they die before you and they have an estate plan and it gives everything to someone else? That's not you. You can lose the house. Okay. So giving your house, your kids, especially if you want to live in it after the fact, is a pretty tricky situation. There are some bad things that can happen potentially. Okay. That's number 1. To summarize that probate pitfall, you can't or shouldn't avoid probate by giving your house to your kids while you're still alive. Probate pitfall number 2 is just not planning to avoid probate. It's actually quite simple to avoid probate if you own a home, if you plan ahead just a little bit. Call someone that can help you, right? And they can tell you how to do it. And I'm going to tell you right now, there are 2 main ways that you can avoid probate with real estate in Washington state. The first is called a transfer on death deed. It's basically like a beneficiary designation for your house. It says, when I die, I want my house to go over here to these people. When you die, they record the death certificate and it goes to them like automatically. Boom. Kind of like a beneficiary designation on a bank account or a life insurance policy. It just happens. No probate, no trust, right? Which is what we're going to talk about next. Very simple. There are some situations when you don't want to do a transfer on death deed. That's why you should talk to an attorney before you do anything crazy. Okay. The second way to avoid probate is with the trust. Okay. Trust is like a box. You're going to create this box. You're going to put your house inside the box. This trust holds your house. When you die, it continues to hold your house. Because of that, there's no need to go through probate and transfer your house anywhere. It stays in your trust. And then whoever you name to be the trustee will distribute that house wherever you want it to go. All right. That's it. 2 tax pitfalls, 2 probate pitfalls, both avoided now that you've watched this video. And hope that made sense. Okay. If you like this video, please hit the like button. If you know someone that should hear this, comment below and put their name in there. Okay. So they can watch it. And if you want to talk with us about estate planning, go to cmslawfirm.com. Set up a time to talk with us over the phone for free. We'd be happy to do that. By the way, I am Christopher Small, the owner, CMS Law Firm. We do estate planning, we do probate, we do it well. Thank you for your time. Thank you for your attention. Appreciate you. I'll talk to you again.